good afternoon. We're on the record in case number D216266861D, Flaxman versus Flaxman. May I please have appearances beginning with Mr. Smith?
Hi, good afternoon, Your Honor. Radford Smith, 2791 on behalf of Mr. Flaxman, who's also present and here via video.
All right, welcome. Miss Chrome, how are you doing?
I'm doing well, thanks. Shaka Chrome on behalf of Melissa Flaxman, bar number 8116.
Okay, welcome. All right. On November 20th, we were in this courtroom doing pretty much putting on the record what was going to be in the marital settlement agreement. There is no reason why this agreement has not been looked over. Ms. Flaxman had very competent attorney who was involved in the negotiations, and Mr. Fleeman should have been the one to have looked over it, signed it, and got it up to me. That order from November 20th was supposed to have been a decree of divorce, getting them divorced before the end of the year, not them still being married. Get me this marital settlement agreement that matches the minutes so that I can sign it and get me a decree of divorce so that we can get them divorced. Am I clear?
You're crystal clear, Judge.
Hey!
I just need time to meet with her. I'll meet with her next week. My daughter has COVID this week, so I'm home. But I'll meet with her next week.
Is your
and we'll
daughter
go
okay?
through it. But there's some changes that I already sent over for the decree of divorce. There's some documents that I still need from Mr. Flaxman that I think she's entitled to see. I mean, she's received checks,
okay,
but she
first,
doesn't have
hold
the
on,
documents.
time out. Was there an agreement for these documents to have been turned over?
Yes.
Okay.
Where?
If there was an agreement and there is an order to turn over these documents, then she gets it. But there's not going to be any changes to this.
She's not asking for changes.
What documents are you wanting?
So it says that he's supposed to provide her with status and for information regarding the ARs and the collections. The number that they've recently provided is $20,000 difference. We don't know if he collected $20,000 or not. We don't know how many ARs there are or not. He's given her some checks. There's no identification on what the checks are related to. We haven't seen any agreements between he and Mr. Levitt. So how are we supposed to know when she was supposed to receive a check for $42,500 and she gets a check for $29,300?
Let me make this clear. We are not relitigating anything.
I'm not saying that, Judge.
Yes, you are. Sign
No.
the marital settlement agreement based upon what was in the minutes. If you don't believe that, then go ahead and get a copy of the hearing, get it signed,
I
get it up
watched
to me, and then if you want to reopen this case, you may reopen it.
I don't.
Ma'am, if you create unwarranted litigation and unwarranted attorney's fees, your client will be paying those attorney's fees.
No, Your Honor, she was supposed to get a check for $42,500. She got one for $29,300 with no explanation for the difference. I think, honestly, Judge, all I'm saying to you is if I can have a conversation with Mr. Smith, we haven't spoken, he can tell me the answer to these questions. No one's trying to reopen anything. I'm trying to get this done. I just need to meet with her.
Okay. This has now been 6 weeks. Next
6 weeks
week,
since when?
it's 11/20, okay? You do the math. It's been 6 weeks, and this is supposed to have been to me within 14 days of that hearing.
But
Which
they
means
gave
it
her
should have
a
been to me
vacation
right at the
letter.
beginning of December. I don't play games, Miss Crone.
I know you don't. I've litigated with you.
I know
and
you've
we've
litigated
gotten-
with me and you've been in front of me, and I love it, but I'm not going to allow your client to play these games. There's no reason why she changed from Mr. Fleeman to you right here at the end of a divorce unless she's wanting to play games. So be sure you let her
They filed a
know.
motion to
Ma'am,
withdraw. They
just
filed a
be
motion.
sure and let her know. We have to come back for this issue. Attorney's fees will be awarded.
Okay, just to be clear, they filed a motion to withdraw and she went out and hired someone immediately. That's it. There was a revised MSA sent over on December 15th and they filed a motion to withdraw on December 17th. So nothing's happened since then. And so she hired me. I sent over revisions to the decree of divorce already. I sent over my changes to the order, and now it's just the MSA. So she immediately went over once they told her that they wanted to part ways with her. So I think I laid all that out, but I think she has the question she's asking should be answered. If she expected a check for $42,500 based on their agreement and gets a check for $29,300, that's a valid question. That's not relitigating. That's just asking where's the difference.
Okay, there it is.
Your Honor, I can explain, and Radford, I apologize. There have been extensive communications provided to Mrs. Flaxman as to the modification of the redemption agreement for my prior firm. And we're talking about 10 paragraphs in length, Your Honor, about why the monies were different than what was agreed upon initially. But my point is this, Your Honor, there's two things. There were two taxable events that changed. At the end of the agreement, Flaxman received $32,488 more than she would have agreed upon in the MOU that we signed has received more monies than we initially agreed upon. And for Ms. Crome to say that we have not provided information as to why those numbers have changed is disingenuous.
All right.
Okay,
Make sure Ms. Crome has the communications between you and Ms. Flaxman. That way she can be on the same page. We're gonna we're gonna put this on for a status check.
Good idea. Judge, there is one thing I think that we need to address. First of all, let me note on the record that everything that is now in the order that arose from the hearing that you had identified has
Correct.
been paid and complied with by Mr. Flaxman.
Mom, stop shaking your head saying no. Stop it. That's one quick way of irritating me.
And the other thing is that Ms. Crone may not be aware of this, and I don't know how much of the file that she received from Mr.
Fleeman.
Mr. Fleeman, thank you. We had submitted the MSA on October 9th, and then you received the previous pleadings that said we didn't get any feedback. So we sort of kind of gleaned from communications he had, and we made some changes, and then resubmitted it again shortly after that time. But as we sit here today, usually when these things happen, Judge, you give them an MSA and they come back with, oh, we'd like these changes to be made. This day, that hasn't been done. And so we're now, between October 9th and January 12th, providing a document that is still we've never been told what was the changes that to be made. So we tried in the last hearing to put those things on the record. We put it into an order. The court has now filed. And we've now complied with that. The only change that's been possibly made benefited Ms. Flaxman by, what was the amount, Mike?
$32,484 in addition to.
She got more money than we were, because the tax consequences were less than we thought they were going to be. And as you recall, Your Honor, from the original document, we had anticipated a withholding of those tax monies. And so the two things that were the most important to me, Your Honor, was that we immediately paid over the money, which we did, and we provided a very clear explanation why that was done.
All right.
Your Honor, there's just one thing that we need to address though today, and that is that because it's gone over to a new year, now they have to file a joint tax return.
Yes, they do.
So I just wanted to note, now we can't, as a state court, compel her to do so because it's a federal question. But if Ms. Flaxman decides that she's going to ignore what could be the tax difference as a result of the filing of the joint return versus a separate return, we would ask the court consider that in terms of the old. Okay.
I would, because this was supposed to have been given to me no later than December the 15th.
Your Honor, they didn't even get over a revised MSA to Mr. Fleeman until December 15th. So hold on. Okay, here's what I want, Ms. Flaxman. Sometimes people make mistakes and says something on the record that they shouldn't. But if you want to speak, and your attorney needs to approve it. Is it Ms. Crome? Is it okay for your client to speak? It's fine. She can speak.
I would just like to say that thank you, Judge. In the last hearing you ordered Mr. Flaxman to pay any funds he received from the company to me immediately. Since that time, he has refused to do that multiple times in writing, and Ms. Chrome did have to get involved with that. When he knew that I was without attorney is when he filed the motion, and Ms. Chrome also had to get involved with that. Why the changes on the MSA were never sent over, I don't know, but I really tried to communicate with Mr. Fleeman, and I would really like to wrap this up as well.
All right, here's what I'm going to say. Number one, y'all are going to have to file a joint tax return if it's going to benefit both of you, not just one or the other. It has to benefit both of you. But if the tax burden is greater than the benefit for the other person, I will have both parties pay the burden. That will become a community debt because guess what? You're still married.
Your Honor, on the
No. That's my decision on that one. Now we're going to come back in 14 days.
January 26th at 11.
January 26th at 11.
Very good, Your Honor.
If I do not have the marital settlement agreement and a decree of divorce to take this off calendar, I want a briefing as to both positions on why. Yes, ma'am?
Can I just ask? I would just ask that we are able to get the information regarding the tax holdback and the other information from the buyout prior to the next hearing so that we are able to review that information.
Your Honor, that has been already provided to our prior counsel by way of the redemption agreement.
Just go ahead and provide it, please, sir.
I will be happy.
We'll do it again. We'll do it again.
No
problem.
Because we do
All right,
have
very
Miss
good.
Chrome, and you know what, Miss Chrome is easy to work with. So we'll get down to the bottom of it. If not, then on the 26th, then I'll have to be a little ornerier.
Shaka, if you have a minute.
Mr. Smith, I'm going to send a letter today of all the documents that would be
How about
helpful.
saving attorney's fees and pick up the phone and call him?
I
It's
was just
cheaper.
going to say, Ms. Chrome, if you have a minute, I'll give you a call right now.
Okay.
I'll give you a call.
Y'all talk, and you may get it done just within a couple of hours instead of it taking 2 weeks.
I hope so.
All right.
For the AB list.
Oh, and Your Honor, we still have had no luck in agreeing on the division of personal property, although Ms. Flaxman has been able to come to the home and create
All right. She was supposed to have gotten that to you. I mean, she's sitting here talking about the November 20th order hasn't been fulfilled.
She did.
So why has there not been an AB list turned over to Mr. Flaxman?
There wasn't an AB list ordered. It was a list
Yes.
of items.
No. This I remember perfectly clear. An AB list was ordered. She was to go over, do a walkthrough, and then prepare an AB list and turn it over. And then Mr. Flaxman got to choose either A or B.
That's not true. That's why they're
Ma'am?
asking for one now.
Guess what? I'm the one sitting here. I know what we discussed and I know what was said. That AB list was supposed to have been done.
We attached one to our exhibits, Your Honor, as well. We attached a new one.
But
We
it's
attached a
not an
list
AB
that was
list.
given to Mr. Smith, and we gave an AB list.
So Your Honor,
that was-
just so we're clear, I'll be able to work that out with Ms. Chrome. We're not going to argue over.
Okay, fantastic, because y'all are spending a lot of attorney's fees right now over stuff that was supposed to have already been done.
I agree.
So,
Thank you.
and it's a good possibility where I will be awarding attorney's fees for the one who is wrongfully dragging their feet.
All right, Your Honor, we appreciate your time today.
Yeah,
and,
thank you.
Shaka, on you call.
Thank
Okay,
you. Mr.
thank you.
Smith, I
All right.
want you to do the order from today, please.
Will do.
Thank you.
Thank you, Your Honor. All right, bye-bye.
Bye.
Bye.